In this educational Estate Planning 101 workshop, you will learn about the basics of estate planning, including valuable information on wills, trusts, and power of attorney. Toward the end, you'll also have the chance to download a free estate planning guide. It's important to understand that only licensed estate planning attorneys can give legal advice, and that information presented in this workshop should not be considered legal advice. Let's begin. What is estate planning? An estate is essentially all the assets a person owns. This can include homes, cars, personal belongings, and financial investments. Estate planning is the preparation of documents and tasks outlining how you want your assets handled after your incapacitation or death. It's a way to ensure that your wishes are carried out, pass property on, help avoid familial disputes, better ensure that your loved ones are taken care of after your death. Different tools are available to help you with estate planning. First, there's ownership title and beneficiaries. This means who is named as legal owner of an asset and who is named to receive proceeds or benefits. Some assets designate beneficiaries in the contract, while others depend on how they are titled. Life insurance policies, for example, name beneficiaries, whereas property depends on how it's titled. The most common legal tools are wills, trusts, and power of attorney. We'll go into detail on these later. To help you understand estate planning, let's look at the most common myths surrounding it. A common myth is that estate planning is just for the rich. That is incorrect. As mentioned earlier, an estate is all assets. So anyone who owns assets has an estate. Estate planning is especially important for people with young children, those with blended families, and those with more complex distributions. Generally speaking, the greater the overall asset pool, the higher the potential for more complex estate planning needs. If your total net worth and assets are more than $10 million, you should work with an advisor and an estate attorney to explore estate tax planning strategies. Estate planning may or may not involve estate tax planning. People sometimes confuse them, but they are different. Estate tax planning is a subset or part of estate planning. It aims to minimize potential estate tax liability, either by reducing the amount of property in the estate or by minimizing the valuation of the property. The federal estate tax does not apply to all estates. It's only triggered when an estate's value exceeds a certain threshold, and those thresholds fluctuate with changes in laws. Don't make the mistake of thinking you don't have enough assets to trigger the federal estate tax. Your assets can add up to more than you may have imagined, and changes in the thresholds could mean you might have to pay taxes. Another misconception is how much of your estate is subject to taxes. Estates are taxed only on the amount that surpasses the threshold, at a rate between 18% and 40%, depending on the amount of the excess. Additionally, some states impose an estate tax. Each state sets the exemption threshold and tax rate. So it's important to check with an estate attorney to see what applies to your estate in your state. Estate attorneys are the only professionals who can provide legal advice. The role of your financial advisor is to strategize on the optimum investment structure within the framework drawn up by an estate planning attorney. It's important to note that estate attorneys are not licensed to provide investment recommendations, so the partnership is critical. Your advisor is best suited for determining the asset location, investment strategies, vehicles, and particular holdings to maximize the estate plan design. Whether you need one or both, estate planning and estate tax planning are not reserved for the wealthy. No matter the size of your estate, a failure to plan is planning to fail. It's far better to plan early than be forced to scramble. Another common myth is that estate planning is expensive. In fact, the very basic tools of estate planning are free. Simple estate planning can be done using online templates and legal software for nominal costs. However, this carries an added risk if you try to manage your estate on your own. For example, each state has separate laws, so downloading the wrong state template could set you up for mistakes. Only a legal professional is able to provide customized legal advice. Please note that advanced estate tax planning can be expensive, but relative to the tax savings, it is worthwhile. Cost is often the top reason individuals fail to make an estate plan. But what often is overlooked is the potential cost of doing nothing. Estate planning aims to minimize probate costs. Estate tax planning aims to minimize estate taxes due. The second most common reason why so few Americans follow through with estate planning is they either can't think about death or think they have time on their side. Don't let these mistakes get in the way. Here are ways to get started. An easy first step is to use the basic free tools of account titling and naming beneficiaries to designate how you want your assets managed. Review these frequently. A best practice is to review them annually. Make sure you don't have an ex-spouse still listed as primary beneficiary, for example. Titling and beneficiary designations are important for another reason. They generally take precedence over a will. A will is a document outlining your wishes for dependents, property, and assets. Without a will, these decisions are made by judges and state officials through a legal process called probate. So, one example of the importance of titling is if you have a bank account titled only in your name. When you die, it may be subject to probate. You may want to consider what's called joint rights of survivorship. This type of title allows the joint owner to assume ownership when one person dies. Another type of title is transfer on death. This transfers assets to another person upon the account holder's death, skipping probate and superseding anything in the will. So, let's cover the types of wills. As a reminder, only licensed estate planning attorneys can give legal advice. But for your protection, true legal documents are ideal. One type of will is a holographic will. This is handwritten and not witnessed. Handwritten and oral wills are typically a last resort emergency solution and have the potential to open a whole can of worms. With proper planning, this can be avoided. A testamentary will is witnessed and stands up the best against challenges. It's the most familiar type of will and ideally is drafted by an attorney in keeping with your state's laws. Then there is a pour-over will. Designed to work in conjunction with a living trust, a pour-over will lets the court know that any assets you neglected to include in your trust should be transferred immediately to that trust upon your death to be distributed as you wish. We'll review trusts in a bit. And lastly, there are mutual wills, which are two separate wills that are largely the same in content and in which each party agrees to an identical distribution of their assets. Another myth is that estate planning is just for seniors. Again, that is wrong. Young families have a need for estate planning in order to ensure wishes are carried out for surviving children. Good planning can really help a grieving family. And having a will is critical to manage distributions and identify who would become the guardians if you and your spouse both predecease your children. As a note, a financial advisor can play an important role in conjunction with estate planning by helping with the financial planning side of the equation. This can include reviewing your insurance plans, planning income replacement and debt coverage, and more. Estate planning and financial planning are a combined force for your needs. For those getting started, here are some tips on what to include in your will. You'll need an executor. This is the key person to carry out the terms of the will. The executor, usually in consultation with a probate attorney, will settle and distribute your estate in accordance with the terms of your will and subject to the laws of your state. When selecting your executor, try to find someone who is trustworthy and has the mental and time capacity to complete the task. You'll also want to include final arrangements, a list of all your property, assets, and prized possessions. Additionally, you should include to whom and how said items in your will be distributed to beneficiaries and a designation of guardian to minor children if both parents predecease their children. Another myth is that a will avoids probate. A will guides the court, but it does not avoid probate. Trusts are the tools used in estate planning to avoid probate. There are three major types of trusts. First, there's a testamentary trust. Established through a last will and testament, a testamentary trust takes effect after you die. The executor of the estate named in the will is responsible for navigating the probate process. Assets cannot be distributed until after the probate process has been completed. Secondly, there is a revocable trust. It's a living trust, meaning you can control your assets in the trust while you're living and specify who receives them when you die. You can appoint yourself as the initial trustee so you maintain control of the trust's assets during your lifetime, but you'll need to name a successor trustee to manage the trust for your beneficiaries after your incapacitation or death. Lastly, there is an irrevocable trust, which cannot be modified. An irrevocable trust is a legal entity that owns property that you transfer into it during your lifetime and that, after your death, distributes the assets to your beneficiaries. The assets deposited into an irrevocable trust are excluded from one's estate. This reduces the value of the estate in regard to estate taxes and also protects the assets from creditors. There are also many special types of trusts. These can include a spendthrift trust, charitable trust, special needs trust, bypass trust, credit shelter trust, generation skipping trust, life insurance trust, and special needs trust. Again, creating an estate plan requires coordination from the professionals helping you. The state attorney drafts the framework, and the investment advisor determines the actual investments that are best suited for the type of trust needed. This is key because there are different rules around the structure of the trusts, distributions, and taxes. Having a team is the best approach. Our final myth about estate planning deals with power of attorney, or POA, which is a legal document that allows someone else to act on your behalf. The myth is that you can wait to appoint a power of attorney until needed. If you fall into a coma from a car accident, or develop dementia, for example, it may be too late to assign a power of attorney. A person has to have the proper mental capacity to execute any legal document, including a power of attorney. If a person's capacity is called into question, then it may require competency proceedings to determine if the needed mental capacity exists. Waiting to assign power of attorney is risky. Power of attorney may be general in its application or limited to a particular activity, such as for healthcare or financial decisions. A power of attorney also can be permanent or for a limited time frame. There is also a general power of attorney, which assigns all of your powers and rights to someone else. Unless revoked, it applies as long as you're alive or until incapacitated. The most powerful power of attorney is a durable power of attorney. It also assigns all of your powers and rights to someone else, but continues even when incapacitated. Lastly, there is a springing power of attorney, which serves as a durable power of attorney but goes into effect after a specific event. In estate planning, for example, the condition could be your incapacitation. Therefore, it's important in this case to clearly define what incapacitated means. Please note, when the principal passes away, any type of power of attorney they created becomes void. Your POA does not have the power to handle your estate. That responsibility falls to the person you name in your will as the estate's executor, or to the administrator that the probate court appoints if no will exists. For more information on estate planning, scan the QR code on the screen with your phone's camera to instantly download a complimentary copy of our estate planning guide. Are you ready to take action? Please remember that this is not legal advice. If you're ready to take your next step in estate planning, you can do the following. Check your employer benefits. Legal support is a growing group benefit you might have access to. You can also check online tools for do-it-yourself templates. Additionally, you can check with your existing professional team, which would consist of your financial advisor or CPA, to request an attorney referral. If needed, estateplanning.com is a website where you can find estate and family law attorneys in your area. Congratulations! You're one step closer to creating an estate plan. If you have any questions, please contact us today. We're here to help. This article is intended solely for general educational purposes, and the content developed from sources believed to be providing accurate information. The information in this material is not intended as tax or legal advice and is not a recommendation to buy, sell, or roll over any asset, adopt a financial strategy, or use a particular account type. Consumers should consult with their tax or legal advisor regarding their individual situations before making any legal or tax-related decisions.